We'll get all that on the record. This morning, 24 CV 010786, which is Abi Rahman et al. Versus the State Election Board. And we also have 24 CV 011584, Adams versus Fulton County. There's some interveners in the mix on both those cases, and we'll certainly work with them this morning as well. We're going to start with Abi Rahman, and I need to figure out, mostly for the court reporter sanity, who will be speaking for the different parties involved. So let's start with plaintiffs. The original petitioners, there are many, and they fall into different groups, and they have different lawyers. Who will be speaking on behalf of the original petitioners?
Your Honor, Ben Thorpe, and then Kurt Castro.
Okay, and Mr. Kastorf, you will be speaking on behalf of the DNC. Mr. Thorpe, you'll be speaking on behalf of all the individuals? Mr. Bailey represents some of the individuals.
Correct. So I will be speaking on behalf of the Democratic Party of Georgia and the voter and candidate individual plaintiffs.
All right.
And Your Honor, I think we've divided ourselves a little bit more by subject matter.
By subject matter, okay.
So I represent the Democratic National Committee, but I'll be addressing standing on behalf of all of the plaintiffs other than the BRE.
Okay, and have you introduced yourself to the court reporter so she knows who's speaking?
Yes, Kurt Kastorf on behalf of...
All right, Thorpe, Kastorf, sir.
Morning, Your Honor. Daniel Volchok for the Democratic National Committee, and I will be speaking on the issue of the Republican interveners' equitable principles argument.
Okay. And we have one more person at the table. You're managing technology, or will you be? For Mr. Thorpe. All right. Got it. And on behalf of the election board.
Hi, Beth Young, and we have Dana Yu here with me from the Attorney General's office. I'll be doing arguing today.
All right. Thank you for being here. And how about on behalf of the RNC and the GRP?
Good morning, Your Honor. Baxter Grinnan. I'll be doing the argument with Brad Carver here today as well.
Okay, great. Thank you both for being here. So, before we dive in, I want to talk about exhibits, and then I have just some threshold questions that will help me cabin what we're going to be discussing, and then we'll get going. Exhibits. Mr. Thorpe, on behalf of the petitioners, have you worked with respondents to see if there are any objections to any of the exhibits? Or are we in a position? You're in a different case, Mr. Siegelman.
I am, Your Honor. I had a quick housekeeping matter related to Adams I was hoping to run by you before we got into any substance on this matter, the Abraham matter.
Okay.
And that is that
Someone's computer needs to be muted. Someone's connected.
I'm working on Your Honor. I apologize.
Okay. We'll go with the reverb. Keep going.
All right, thank you, Your Honor. It's just if Fulton County's representative is present, but has a competing commitment this morning that she
Who is that?
Sherry Allen, the chair of the Fulton County Board of Registration and Elections.
Okay. Hello, Ms. Allen.
Good morning, Your Honor.
Thank you for being here.
My question is simply, if the Adams case will be heard after Abraham and after the break, would it be permissible to excuse Ms. Allen, just for the portion of the Abu matter, she can come back for the Adams versus Fulton County matter.
That is fine with me. I can't give you a specific time when we'll be pivoting to Adams, and I can't guarantee that I wouldn't have a question for you. It probably wouldn't be for Ms. Allen, but I might have a question like, whoa, that's interesting from this case. What is the county's perspective, or what is Ms. Adams' perspective on that issue while we're talking about it? If you don't think that requires the representative from Fulton County to be here, I'm fine having people step away and come back when it makes sense for them. So I don't know if that was a helpful answer. What I can tell you is in the next 5 minutes, I won't say, let's start with Adams instead.
No, I understood, Your Honor. Thank you for that. And counsel will be present for the entire time.
Great.
Ms. Allen may step out and come back.
Great, sounds good.
Thank you, Your Honor.
You bet. Enjoy the competing event.
I'm representing veterans at a legal clinic.
All right, good. So, Mr. Thorpe, back to exhibits. What's the stat? I know I appreciate there's been a lot of back and forth about, hey, can't everything just be admitted up front? Because this is more about the legal argumentation than the exhibits supporting them. Where are we in your case?
I think we are there, Your Honor. We have listed 35 exhibits as plaintiff's exhibits. I think both the SEB and RNC and Georgia GOP have agreed to their admissibility, subject to a very minor caveat that I'll let Ms. Young explained. I think we've also agreed that affidavits may be considered for their substance in lieu of live testimony, and I think we've agreed that the sole SEB exhibit, which is an affidavit, should also be admitted. So I think we are squared away and would move for the introduction of all those exhibits at the outset.
Okay, with one caveat. What's that, Ms. Young?
Simply that we reserve the right to raise objections to the use of the exhibits, such as Purcel or that kind of thing, as they come up. But we have no objection to general admissibility.
Making them in the record. So I can consider as part of the record all of the exhibits from petitioner's side, as well as the lone exhibit from, it sounded like there was one, the affidavit from respondent's side.
Most of the exhibits cover the things we would need to.
Right. Okay. Mr. Drennan, anything you want to add in terms of exhibits?
No, sir.
Good. Well, we're squared away there. That's very efficient. So here's my question. I want to know if anyone on petitioner's side disagrees, I think I know the answer, that certification of the November 5th or any election is mandatory.
We do not disagree.
Do not disagree. And Ms. Young, it sounds like the state election board does not disagree that certification is mandatory.
Correct. It's mandatory.
Mr. Drennan, you agree?
Yes, sir.
Okay. Second question. Does anyone on petitioner's side disagree that this mandatory certification must occur by 5 p.m. November 12th?
We do not.
Okay. Ms. Young?
Correct.
Mr. Drennan?
No disagreement.
All right. Last question, and I think we will be in a fairly narrow space when we're operating, while we're making our arguments. Anyone on petitioner's side disagree that the state election board lacks the authority to change either the mandatory nature of certification or the deadline for it? They cannot pass a rule, a regulation, anything that would make certification non-mandatory and change that deadline for this election of 5 p.m. November 12th, 2024.
I want to be sure I say this correctly. We do not disagree with that.
Okay. Ms. Young?
We do not disagree with that.
Mr. Drennan?
No disagreement.
All right. So it feels like to me, for this case, I think the other case, but I haven't asked the parties to the other case, we are debating what election superintendents, and that would include boards, but the generic term is superintendent. So when you hear me use the word superintendent, awkward moment. Of all the rings to have, too. Not a subtle one. That superintendents, what we're debating about is what they can do in the period leading up to certification, and whether we call that work ministerial or discretionary. But we're not arguing about must there be a certification and must it be by that deadline. So based on the answers that everyone in this case has given, that's what we're debating about. So I'd like you to start, well, I don't know which topics, how you divided it up, but my first question for petitioners is, what is the uncertainty under which they labor, because you are seeking declaratory relief, which says you're not certain about something, your clients aren't certain about something, and apart from maybe your clients, I speak writ large for the petitioners who are in fact superintendents, I'm not sure what legal uncertainty any of the petitioners are laboring under such that I need to declare anything. Because if you're the party, if you are a voter, the election will be certified, must be certified, shall be certified, November 12th, 5 p.m. So other than the people who have to do the work that results in the certification, I want to understand what the uncertainty is that is properly addressable by a declaratory judgment, as opposed to an advisory opinion or a reassurance from a judge that, don't worry, your vote will count, which is an important feeling to have, but not what a judge is supposed to do.
So I want to be sure that I understand the question, Your Honor. You are setting aside the BRE member plaintiffs for this question, or you are, I'm sorry, petitioners, or you are including the BRE member petitioners?
Both. It's a two-part answer. The threshold for many of the petitioners is, what's your legal uncertainty? It's a standing argument, but I think we ought to address that first. It doesn't mean we stop the discussion. It just means that really the focus is going to be, if there's a declaratory judgment issued, it will be declaring the rights and responsibilities and clarifying, I believe, the path forward for superintendents, and not for a party and not for a voter, because you're going to go to the polls and you're going to vote, regardless of what I say about the reasonable inquiry rule or the examination rule. You're going to vote, and that's sort of where we are. So it's that two-part question, and it may be different of you answer it, but that's where I'm going and working through this. I don't mean to upset the flow that you had for your presentation, but that's going to get us to the issue sooner if we focus on what that uncertainty is for those two groups, the people who actually have to do the certification, superintendents, and then everyone else who is legitimately and understandably concerned about it, but doesn't have a role to play in certification.
Understood. So just as it relates to our sort of plan for presentation, I was planning to present that as to the BRE petitioners, which include, they are members of the superintendent bodies. Mr. Kastorf is going to speak separately to sort of voters and organizational interested parties. It sounds like you may be asking for that first.
Yes.
First.
Great. Sorry, you may have thought you were going second, but in terms of where you are when you speak, I don't need you to go to the podium. You're welcome. Some lawyers, they have to stand for it to work for them. Oops.
Your Honor, because this is expedited, I have SCOPUS across the country online working on this, cleaning it up. I need a very good audio for them to hear it. So to their benefit, they need to really speak up if they're going to stay there or...
Well, let's make sure your microphone should have a green light in front of it. If it's red, no one can hear you.
It has a red right now.
Okay. Did you make it green? You put your finger in that little well.
It's now green.
Ooh, now the scope is like Mr. Kastorf. They have no idea what Mr. Thorpe just said, but I'll let the scopus know. It was compelling. Similarly, on respondent side, is your microphone green or red?
It's red right now, Your Honor.
So let's get the little finger in the well. Ms. Yu contributing already. Did you make it green? You just tap. Don't hold that. Just put your finger in it. Tap. Good. All right. Thank you, Court Reporter, for doing that. All right, Mr. Kastorf.
Yes, Your Honor. I had planned to start by promising that I would be very brief because I was mostly going to defer to the wise counsel, Mr. Thorpe. Since you're making me go first, I might take slightly longer, but I'd begin by noting this court was correct in our pre-trial conference to note that it only takes one for standing. We think that the BRE plaintiffs have an extraordinarily strong sort of ironclad under recent Supreme Court jurisprudence that they have standing to bring this claim. And they do face uncertainty both about whether they do have any obligation, whether they have an obligation to hit their deadlines, because prior to the filing of these trial briefs, there was some ambiguity about whether anyone was asserting they could skip a deadline. But even assuming the finality of the deadlines are in place, the reasonable inquiry rule, what exactly it calls for them to do, is certainly in flux. So given that standing exists, I intend to be relatively brief on the remaining plaintiffs, but we do want to make a case because, among other things, even if the court is going to decide it as the BRE, this case will go on appeal, and who knows how it might come out.
Sure, and to be clear, I would like to get as close to right as possible, and if right is there is legal uncertainty for a party or for voters, I need to address that. It's just as I was processing all the very helpful briefs, and I have to admit I did not read the amicus that was filed at 8:30 this morning, so we'll get to that later. It became clearer to me that the parties in this case actually agreed on a whole lot of what originally maybe had been part of the debate. In other words, certification is mandatory, and so that pushed things back to, well, the days leading up to it, and it would be more the actions of superintendent. So I don't want to exclude people from declaratory relief if I shouldn't, which is why I'd like to hear from you.
Well, let me begin with the voter plaintiffs. The defendants don't deny that the voter petitioners have constitutional standing, and there's a reason for that. In Cobb County v. Floam, which was decided earlier this year, and defendants cite for their argument on statutory standing, the Supreme Court of Georgia unambiguously held that community stakeholders have standing to enforce a public duty and thus may seek to challenge an agency rule. I think the court's question gets at more the question of statutory standing, which let begin with an assessment of the words of the relevant statute. OCGA 50-1310 provides that the validity of any rule may be determined in an action for declaratory judgment when it is alleged that the rule or its threatened application interferes with or impairs the legal rights of petitioners. And the Court of Appeals has explained in Peach Hill Props 280 Georgia 624 2006 that such language should be construed liberally wherever a legal judgment could control or direct future action, or where rights are or may in the future be affected by a statute or action.
So if everyone agrees in this case that certification is mandatory and the deadline is fixed, what are the legal rights of voters that would be interfered with through the reasonable inquiry rule and or the examination rule?
Well, voters have a legal right to have a valid to vote, and that includes the right to have a validly cast vote counted. As an initial matter, although the parties to this litigation will appear to agree that certification is mandatory, as I mentioned, that was not clear until the trial court briefs were filed. And so we think that a clear ruling of this court benefits those plaintiffs by making sure that certification is in fact mandatory and non-discretionary. But even assuming that certification is mandatory and not discretionary, the reasonable inquiry and the examination rule seem to leave open a role for county officials in the certification process that may not have been envisioned in the statutory scheme, which leads to at least the possibility that some voters, otherwise validly cast ballots, could be excluded during the certification process and not count until the election. And that is a cognizable harm faced by voters. Here, the voter petitioners, Johnson, Wakefield, and Waits, each have standing because they are voters of Georgia. And the uncertainty of the challenging rules that the challenge rules inject in the certification process create a risk that the county board of elections might not certify their votes, might not certify at all, or might not certify in time.
So those last two, we don't need to talk about anymore. It would just be that an individual vote might not be counted. And what is it about either of the rules that suggests that my vote wouldn't be counted?
Our concern is that the requirement of a reasonable inquiry and the examination rule create the possibility that a county official could believe that they had an obligation to investigate or engage in some sort of inquiry into irregularities that are not contemplated by the statute, and could conclude that they can't certify a particular, either their entire slate of electors that they can't vote for certification, or that there are voters that they have the ability to exclude under the statute.
I don't want to get out of your lane, but someone will need to address why isn't the outcome of the scenario you described, given that everyone is saying certification is mandatory, there's a fixed deadline, a certification with reservations. I'm certifying, but I think that the votes from precinct 19 are suspect because I examined some things and I see an issue there.
Well, that would not unambiguously be a permissible outcome unless and until this court declares that, right? Our concern is that absent a ruling from this court, a county official could believe that the appropriate remedy, if they cannot determine justly that a particular vote is to be counted, to exclude it from the certification total, to abstain from a vote on certification, to refuse to vote for certification. All of these are possibilities that a county official could take that would prevent a voter from having their votes legally cast.
Under which of the two rules, or was this something you think they could have done last election?
No, we believe that the statutory scheme clearly does not allow that type of action, and the reasonable inquiry and examination components of each of the rules create the possibility that a county official can believe that. Now, it is true that the court could say, I am explicitly limiting the scope of these rules to mean that it could not mean any more than what the statutory scheme says, and here is what the statutory scheme says. But absent the court making that ruling, the voters face a harm, which is the reason they have standing. They have a basis for you issuing an order because it would not merely be advisatory. The effect of you issuing that order would be to ensure, or at least significantly increase the odds that county officials apply the statute as it is written.
Okay, and this is why we're proceeding under 50-13-10, and it's a slightly different approach to declaratory judgment. It's not the classic, I don't know how to proceed because the legal rights aren't clear. A voter knows what to do. You got to go vote. And if you don't vote, your vote won't be counted. This is an attack on these rules, suggesting that the rules, if implemented without certain clarifications, could result in that outcome you described, which is a superintendent deciding, because of my examination of these records, I'm going to certify but not include these votes in the certification. That would be the uncertainty that would result in a negative impact on a voter's rights.
That's correct, Your Honor, and it's significant, among other things, because the State Election Board is citing the Floam case for the notion that there is not a statutory right. The Floam case is primarily an interpretation of OCGA 942, the sort of general declaratory relief statute, and there's at least two important distinctions between that and 50-13-10. The first is that 942 specifically incorporates an actual case of controversy requirement. As this court may be aware in Floam, one of the things Justice Peterson is struggling with is the fact that Georgia courts have routinely used Article III standing ideas and incorporated them into law when they don't clearly apply to the Georgia Constitution, which does not contain Article III.
Right. He and Article III have a troubled relationship. Let's pivot, because I know you didn't want to take too long, and I've been dragging it out. I apologize. Party uncertainty.
Party uncertainty. So, in addition, both the Democratic Party of Georgia and the DNC have multiple bases for standing, both associational and organizational. I won't talk about associational extensively because the short version is, if this court concludes that voters and candidates and, in fact, BRE members, who also in some cases are members and constituents of the Democratic Party and the DNC, have standing, then so too do the parties. So let's move to organizational standing, because that would be, if this court were to conclude that any of those classes do not have standing, it could consider organizational standing. The organizations have standing for two separate reasons. The first is that each has been and will be injured directly by the challenged rules, because each is injured when votes for Democratic candidates are not properly certified, thus reducing the chance of Democratic candidates being elected. Likewise, DNC and DPG are each injured when citizens are denied their fundamental right to vote, because part of each organization's mission is to ensure that citizens can exercise their political freedoms. And any delay in certification or refusal to certify either the entire slate or part of the slate will thus harm DNC and DPG by infringing that right.
Okay, so it's a natural parallel to the concern you've expressed under 50-13-10 about the voters' rights being impacted. It's the party's rights. If there is something going on with certification that you have a superintendent who feels empowered by the rules to exclude some votes, that could result in an unfavorable outcome for a candidate of the party. There's the impact.
That's correct. The one thing I'd like to stress is that the parties also do have an independent basis for organizational standing, which is that the challenge rule is injected into the certification. It will cause diversion of those organizations' resources. And we filed affidavits on these points, one from the voter protection chair of the Democratic Party, and one from the DNC that explain in very concrete terms why there is an active effect. Because, among other things, the parties, the DNC and DPG, jointly run a county liaison program where both staff and volunteers reach out to the counties to work on issues that include certification, but also include a much broader basket of things, where they're going to administer early vote, how absentee ballots are going to work, how registration is going to work. And our county liaisons, in working to ensure that these new rules are not interpreted in a way that disrupts the statutory scheme, concretely have less time, resources, and political capital with the counties to express those issues. Now, that is a point that is not addressed at all in the state election board's briefing. I suspect they may point out that it is still somewhat ambiguous under Georgia law, the scope of diversion resources standing. However, all the Georgia Supreme Court has said on that is that whatever diversion resources standing means, it does not mean that the very cost of litigating issue itself is diversion resources. And to be clear, the affidavits that we have in the record that we've stipulated can be agreed to the substance are not based on the litigation cost. It's based on the actual tangible diversion resources. And the 11th Circuit in Browning, the NAACP, has clearly endorsed these theory. You've noted that the Supreme Court has not made it. Article 3 cases are not binding, but may be considered for persuasive authority. And we think that existing law effectively sets out the distinction. And the 11th Circuit also draws the same distinction the Georgia Supreme Court does about litigation costs. It's aware of that distinction and has still found diversion resources to be a viable theory.
Okay. Got it. Mr. Thorpe? The uncertainty, it's okay, you can move it, that your clients face.
Yes, so technically these are Mr. Bailey's clients, but I'm going to speak on their
Collectively, your clients.
Collectively, the petitioners face uncertainty, and I think the uncertainty is clearest with respect to BRE petitioners who are presently facing uncertainty on their multi-member boards. If possible, I'd like to share a printout and also go ahead and put this online. I think we've got copies.
That's fine. It looks like your tech assistant is making it work. While that's coming up, I'm curious, I think we can dispatch with the examination rule pretty easily because that seems to be a permissive rule, and I struggle to see how that presents uncertainty to anyone because it permits access but doesn't obligate anyone to do anything. It says you may, but not that you must. So I'm not sure if I were a superintendent, I might feel emboldened and empowered, but not obligated to do anything that confuses me. Okay, if I want to ask for more records, I can. I'll find out what I can get if I exercise this new authority that the state board has given me. That's very different from reasonable inquiry, but I don't know that the examination rule lands. I'd like to hear how that lands your clients into a pool of uncertainty, as opposed to reasonable inquiry. That one to me, on its face, is vague and needs clarification.
Sure. So if folks don't mind turning to slide 9 of this presentation. I'm going to make everyone come back to all these slides. The examination rule includes multiple sort of pieces of the puzzle. And so I want to distinguish between a couple of those pieces, which are also spoken to in the affidavits from the BRE petitioner. So point 1 within the new rule actually does impose a direct requirement on boards, and this gets at the uniformity argument that we make later, to meet and conduct a review of precinct returns on Friday at 3 p.m. Our BRE petitioners, several of them, have noted that that creates a direct and actual concrete problem for them because it requires them to meet before all of the returns are complete. The UOCAVA ballots and provisional cure ballots have not fully come back to the superintendent at that time because the deadline is actually after Friday at 3 p.m. It's Friday at 5 p.m. So that is a concrete harm that the BRE petitioner plaintiffs indicate is imposed upon them directly by the examination rule. That is separate and apart from the all-election related information prong of the examination rule that I think Your Honor's question is about. So I want to distinguish between the two.
Okay.
Flipping to slide 10, however, I think this gets at your question. Part 6 of the examination rule says that board members shall be permitted to examine all election-related documentation created during the conduct of elections prior to certification of results. In the abstract, that may make some sense, right? It is a
Why doesn't it make a ton of sense? Why does that, why wouldn't we want 6?
So we want transparency as to the elections. There's no question. And there are any number of rules that say at the time that the superintendents are completing tabulation and canvassing and certification, they have access to information that is really described fully by statute. But
does the statute limit it to that, or does the statute say, here are the things you have to get, and now the board, the state board, has said, well, you can get more if you want it, you don't have to, you shall be permitted, so if you ask for these additional things to do your job, you should be able to have access to that.
And I think the uncertainty that that imposes on the BRE plaintiffs is that the state board does not provide, much as with reasonable inquiry, any definition or boundary on what that election-related information includes. So we see in the affidavits from the BRE petitioners concerns, present concerns, about how scarce staff resources, for example, can be used during that essential week between when votes are cast and when the certification decision has to happen in order to manage escalating and cascading requests for individual, potentially ballot information from BRE members. So the Mossbacher affidavit speaks to this in paragraph 11, that's on the left, and the Abhiraman affidavit indicates the potential consequence of a circumstance in which there are just ongoing requests for more information. The consequence being that an individual member of a board may say, I have not been able to receive all election-related information, which is required under the rule, and so I cannot certify. So this is why, similar to the reasonable inquiry rule, we think that this prong of the examination rule creates an element of undefined or unbound discretion for individual BRE members to potentially deny certification.
But you must certify. Everyone agrees you must certify.
Everyone in this room agrees that you must certify. That's correct. So
I guess we need to count all the ballots in this room because they must be certified. Okay, I understand your point that the parties to this litigation agree that certification is mandatory. And so the response to the scenario you described would be, hey, I'm certifying, but the world needs to know, no one let me look at these documents, and so there should be cause for concern. I asked for the ballots from Precinct 9, and because of time limitations or because people don't like me, I didn't get to see them. So certification dubitante. I don't know how certified this should be, but I have to certify, so I'm certifying.
And to the extent there is evidence like that is outlined in the course of a given superintendent certification decision, we have placed where that evidence belongs. It belongs in an election contest.
Right.
Or
something is delivered to the relevant district attorney, as it says in the statute.
Correct. And I think what you asked Mr. Kastorf earlier is the correct way of thinking about this. The concern, the actual concern that these BRE petitioner plaintiffs have is that the rules, if implemented by the letter without any clarification, bear the risk that is not the way in which other superintendents read those rules, not the way that other actors in the course of the process read the rules. And that's not to say that our petitioner plaintiffs are not also affected in their own interactions with the other members of these multi-member boards in the interim, right? This does not all occur in a vacuum where they're just making an independent decision about certification. There are any number of resource allocation decisions, any number of decisions around staffing and availability of information that happen in a collaborative way during the tabulation, canvassing, and certification process. And those actual interests are affected presently because the rule is effective and because the rule is driving conversations in these boards. And I'm sort of repetitive on that because I think it's necessary to understand, consistent with Mr. Kastorf's discussion of Floam, that it is their conduct, our client's conduct, that is currently affected by the uncertainty in these rules. It is not only those petitioners that may choose to vote against certification or choose to delay certification. It is everyone at the level of superintendent, and that's why the need for a declaration is there. So I do want to speak to sort of two other things before we separately discuss the reasonable inquiry.
Okay.
which if we could look at slide 11, it is also the case that the BRE petitioner plaintiffs face potential sanction if the SEB interprets that they are not hewing to the letter of or the spirit of either the examination rule or the reasonable inquiry rule. So the Mossbacher affidavit in paragraph 8 indicates the concern that SB 202 allows the takeover of county boards under this three strikes approach. And the concern is an individual member of a given county board may come to the SEB and say, I wanted all election-related information. I was not able to get XYZ individual ballot in time for the certification decision. That is a strike. That is a concern for sanction that goes directly to cases like Black versus Bland Farms, where there is a direct impact on the petitioners that gives rise to an actual and justiciable controversy. The second, which is to echo a point that Mr. Kastorf made, is it is also in the Ugarte Baldwin affidavit that this directly affects the DPG as well, because around the state there are DPG nominated or appointed, it depends by county, BRE petitioners, not just the 5 petitioners that are in this litigation. And so that's sort of the predicate for the association standing. I want to be sure that I've addressed your questions about the examination rule.
You have.
If I could, I would turn to the reasonable inquiry rule, because I think we've sort of set up that discussion. If we could go to slide 7. The reason we're here, honestly, is because reasonable inquiry is so undefined, right? There is a petition that offered up this rule. That petition was offered up by a member of the Fulton County Board of Elections who had just voted against certification. There is another case we are going to hear right after this one, which involved a Fulton County Board of Elections member that had voted against certification. In both of those circumstances, and this is from the petition itself, what was expressed is there were problems with the election in many places, but were they serious enough to consider not certifying the results? And so what the reasonable inquiry rule, at least as it was presented, was designed to offer was a way in which an additional non-statutory step may happen between tabulation and canvassing and the certification decision that could get at that question, that could allow, to use Mr. Heekin's words, these individuals to use their professional judgment in the certification process. I am very glad that the SEB has in this litigation conceded that this is a mandatory obligation, and even more glad that the RNC has conceded it, because that was not entirely clear from my read of their trial brief. That said, I think the proponents advancing this rule and some of the discussion that happened in the adoption of this rule indicates that there is uncertainty about the scope of how far reasonable inquiry can go. And our petitioners are already experiencing what that uncertainty looks like.
Isn't the scope, though, defined by you've got a few days? I mean, the reality is if certification is mandatory by the date we've discussed, it's what you can do. And someone noted in one of the briefs, gosh, if you work 24 hours a day to look through the things you asked for, you'd need 14 days to do it. As we'll give you this material, but you don't have 14 days. So enjoy, and you'll be making your reasonable inquiry, but you won't finish before you have to do what you have to do, which is certify. And you could add a note saying, I wish I had more time, and then the legislature could change it. But the deadline is the deadline. Get done what you can. And what is reasonable to one person might be not reasonable to another, but you're making your inquiry, and then it's wheels up at 5 p.m. on the 12th of November.
And so to the extent this court does not invalidate the reasonable inquiry rule, it should say precisely that, right? The Crawford affidavit.
Reels up?
Yes, reels up. The Crawford affidavit, which is on this page, actually makes exactly the point that you were just making.
Oh,
which
it's a
is
good affidavit.
a BRE member indicated that it would take weeks for them to decide whether to certify. Well, the law is that you do not have weeks. And so it is necessary, given the statements from a variety of members on these multi-member boards, that the court make clear, because the rule does not make it clear, that that certification has to happen by the deadline. It is also the case that that illustrates that there's uncertainty as to our petitioners, our clients' future conduct right now that arises directly from the rule. As Ms. Crawford states, if the same BRE member or any other member delays or refuses to certify based on either of the new rules, I am not sure how I should respond and work with them in a way that complies with both the new rules and the other statutory requirements. And that's really the central issue, is that we have 5 BRE petitioner plaintiffs here, but also DPG members across the state that are uncertain as to how they can meet both the requirements imposed by this rule for relatively unbounded discretion during that reasonable inquiry and the statutory mandatory certification deadline and requirements. That this distills it in a way that I think is quite concrete, which is the requirement under the law.
Okay.
If I could go to the next page to a couple other pieces of BRE petitioner plaintiff testimony. Further illustrations that this is concrete come from both Forsyth and Cobb. So the Tucker affidavit speaks to the situation in Forsyth, where there is the concern that a majority members of the board will in fact decline to certify, and that is a present concern. There's an attempt to have...
Help me understand, this is the second time you brought up this scenario. I'm on the board, my colleague is refusing to certify, I don't know what to do. I don't understand the origin of that. I'm certified. I know my job. I must certify. It's November 12th. I certify. I don't know why this guy's... I do know why he's not certifying, because he hasn't finished his reasonable inquiry, and he's going to protest that. I think he's not complying with the statute, but why does that decision of another board member create uncertainty for me? I don't see that connection. Your affiants are not saying, we think the statute is unclear and certification is non-mandatory. They're saying it is mandatory and there's a clear deadline. So do your job. You, as that board member, would certify. And there may be larger uncertainty for voters or the party, but not that board member as to what happens if one board member doesn't certify and one does.
So these board members are members of multi-member boards that are collectively a superintendent in a given county.
Right.
The superintendent has statutory responsibilities and duties in that county, and our individual petitioners have responsibilities also to help that superintendent meet what they understand to be its statutory duties. To take the Tucker affidavit example, if the situation is that a majority of Forsyth County board members decide not to certify, the uncertainty isn't for Anita Tucker, will I cast a vote to certify or not? The uncertainty is, how do I get the superintendent, the body to which I have sworn an oath and have responsibilities, to appropriately meet its legal obligations under that circumstance?
Okay. So it would be if there was a majority not to certify. Not one person doesn't certify, I don't know what to do. That creates discord. I'm uncomfortable with it. Okay, but it's still 3-1 to certify, whatever, 4-1 to certify. And that's an oddity, and maybe someone needs to deal with that in the future. But if a majority of the board does what it's supposed to do under the law, not the rules, then there's not uncertainty. But you gave me a different scenario, which I better understand and didn't jump out from Tucker, which is I'm in the minority having certified. The majority hasn't certified. How can this body of which I'm a part comply with the law, which is, hey, it's 4:30 on the 12th. We need to do something, and 3 of you are in the corner pouting with the numbers you can't count in time. What do we do? The other 2. And I understand the issue. Okay.
Okay. So yes, I've spoken to the majority circumstance. I agree with you, the minority circumstance presents a slightly different question, but I think there's nonetheless legal uncertainty in the meantime about all of the other things we've discussed. Resource and staff allocation, the possibility that the delay, that there will just be a refusal to be present for the vote or otherwise, that creates essentially logistical problems for the superintendent in meeting its obligation at this clear statutory deadline. I will, I don't want to talk too much more about the rules. I do want to talk about how the factual uncertainty that we have just highlighted is sufficient to create a justiciable issue for that the court can decide, because I think that's part of where your questions come from. I had planned on talking first about sovereign immunity. My guess is I should sort of skip that for a moment, talk about standing for a little bit, and then come back to it if it's helpful for your own.
Okay.
So, slide 5. I mentioned this case before, Black versus Bland Farms, which was a challenge to a regulation involving Vidalia onions. I think that there are a few lines from the quoted material in this case that illustrate this precise type of uncertainty that our BRE petitioner plaintiffs at least, if not also the voters, candidates, and parties have here.
And Bland is a APA
Yes,
deck action, not a Title IX deck action.
correct.
Okay.
Correct, and that's very important. So I've got OCGA 501310 at slide 2, but Mr. Kastorf has already talked about the language in there that's so helpful for us here, which is if a rule or its threatened application interferes with or impairs the legal rights of the petitioner, a declaratory judgment may be rendered. Bland embodies that rule and applies it in a circumstance where the plaintiff in that case has a rule that it is automatically affected by. I don't think there is any question that both the reasonable inquiry rule and the examination rule automatically affect the members of superintendents around the state. They are subject to it. There's no question about that. The question is, are they subject to it in a way that creates some actual controversy around how their future action may be directed or controlled? The answer to that is yes, in part for the reasons that we've already discussed, and in part because of something else that Bland Farms says, which is if Bland Farms fails to comply with the new regulation, the commissioner has statutory authority to impose civil and criminal penalties. The SB 202 takeover argument that is in the Mosbacher affidavit is a potent illustration of that, but so is the Forsyth example that I just gave. We would have an individual who was unable to meet her duties to that superintendent because she was outvoted by a majority that did not obey the statutory mandate. There are other cases that embody this principle as it relates to Declaratory Judgment Act and rule interpretation, but the essential principle in all of these is that what's necessary is that future conduct, and really present conduct, depends on resolution of uncertain legal relations. And I think we've sketched out as a factual matter why that's the case here. I want to go to the next slide, slide 6, and explain a little bit further why Cobb County versus Floan kind of proves the point. Right? So this is a very recent standard case from the Georgia Supreme Court in which the court found declaratory judgment was not appropriate, but issued what we think is a very important footnote that frankly drove the way that part of this case is structured. The court made clear the fact that there are two competing maps, this was a redistricting case, does create significant uncertainty for many. Footnote 7. What does footnote 7 say? It says there's an amicus brief from the Cobb County Board of Elections and Registration pointing to its own uncertainty about whether a particular amendment is valid and asking for declaratory judgment on that. The Supreme Court was not in a position to grant that there because the BOER was not a party to the case. Here we have BRE petitioners that are party to the case, and given their duties in administering elections, that, to quote Floan, is the kind of uncertainty that would support a declaratory judgment. Jen Mosbacher is a member of the Cobb County BOER. She is a petitioner in this case, and her interest is very similar to the interest that Cobb County articulated in its amicus brief in that case. They wanted to implement a solution to a problem in time for the qualifying period that is statutory, same as the statutory period here, and they wanted to do it with enough time to undertake quality control measures, same as the resource allocation and staffing concerns that all of our BRE petitioners have indicated here. Cobb County versus Floan is powerful evidence that the BRE petitioner plaintiffs at least not only have standing, but there is an actual and justiciable controversy that allows you to render a declaratory judgment that clarifies the rights and obligations under the statute. I will flip ahead to a slightly different justiciability argument that I think is raised principally by the RNC. I don't really see the SEB making this argument in the same context, though I think some of the my response to it answers some of the reasons why declaratory judgment is appropriate in response to SEB arguments. And that is that the RNC and Georgia GOP characterize this challenge as a facial challenge. This is on slide 12. I apologize. This is not a facial challenge, right? So the facial challenge cases that the RNC brief cites quite liberally are cases like Washington State Range, which is a ballot design case, essentially, that is truly a facial challenge. As that case made clear, there was no evidentiary record, and the courts had had no occasion to construe the law in the context of actual disputes or to accord the law a limited construction. That is the precise opportunity that the court has here. This is not a constitutional challenge. This is not a facial challenge. This is a challenge to the validity of an administrative rule operating under the rubric of 50-1310, which has a very clear and established way of looking whether rights are affected. And they are affected here, right? So we've sort of walked through each of these examples already, but there is uncertainty that arises from the undefined but required reasonable inquiry. The Tucker affidavit speaks to that. There is present, meaning there is no future contingency required, present expenditure of time and resources in assessing current obligations about how to meet the obligations of these rules. There is concrete uncertainty about the balance between rule obligations and statutory obligations. There is the SB 202 takeover risk that we have discussed. And there is an immediate and present need to determine staffing in response to the requirements of the examination rule. Whatever issues the reasonable inquiry rule creates, and I think we've discussed this a little bit, the examination rule supercharges. The record evidence before this court demonstrates that practical reality, and that is entirely distinguishable from cases like Washington State Range, which were facial constitutional challenges and had to be decided without any sort of evidentiary record. So I want to answer any questions that the court has. I think that generally sort of concludes both the arguments as to responding to justiciability issues that are raised by the respondents and explains why we think these rules at least purport to confer some degree, or could be read to purport some degree of impermissible discretion. There are a number of phrases that get used in the RNC brief in particular that I haven't expressly spoken to, like advisory opinion and future contingency, but I think for the variety of reasons we've discussed, those are covered by the actual controversy and justiciable controversy arguments that we've made so far. So I'll stop for a moment and see whether the court has any questions on that.
I don't. I'm trying to remember what. I'll make sure we have time for everything. Mr. Volchak, you were going to cover what part?
The Republican intervener's Purcel argument, Your Honor.
Okay, got it. I don't know if anyone wants to address the alleged invalidity of the rules. I mean, I think we're dealing here more in the proper space, which is how to interpret and apply these rules, but petitioners did argue a little bit. You know, there wasn't the concise statement provided, and maybe one of the rules isn't uniform, the examination rule, because it says boards and not superintendents. And I don't want to preclude you from talking about that, but those seem to be secondary arguments rather than primary. And I didn't know if that, it doesn't sound like that falls on Mr. Volchak, so I don't know if that was part of your PowerPoint. We just didn't get to it.
It is, and it's discussed on page 13, Your Honor, but I don't want to spend more of the court's time on those arguments right now. I will say, if a concise statement of the rule, in support of the rule and the reasons for overruling objections to the rule is coming, it's time.
Okay. I don't know that there's a deadline for it, but we do have an affidavit that says it's coming. So,
and we do have an election in 6 weeks that will turn on, in
Right.
5 weeks, that will turn on that rule in part, if not invalidated or construed by this court. The only other arguments that are within the ambit of that presentation are sovereign immunity arguments and a response to the RNC argument about exhaustion. I think that those slides largely speak for themselves, though I am happy to address any arguments that or questions that the court might have.
Okay. Well, what we'll do, assuming there's enough time, I want to hear from Mr. Wolchuk, and then we'll hear from the respondents, and then I'll turn back to the three of you for any last word as the petitioners in this case. You may have something responsive you want to say. So let's see where we're going.
Thank you, Your Honor.
When you're ready, sir. And you don't have a microphone right there, so
I'm going to approach the podium.
You got to go to the podium,
I don't
sorry.
usually have a problem being heard, but just to
Yeah.
be sure. So good morning, Your Honor. Again, Daniel Volchok for the Democratic National Committee, and I want to speak to, as I said, the Republican interveners' argument about Purcel, the U.S. Supreme Court's Purcel line of cases. So those cases say that ordinarily lower federal courts should not enjoin state election law shortly before an election. And the Republican interveners say that those cases preclude any relief here, but that's wrong for a couple of reasons. First, the Republican interveners' argument really turns Purcell on its head.
Isn't the larger issue, why are we getting rules right before, I mean, isn't a lot of what's flying out of the state election board right now inconsistent with the principles that animate Purcell?
Absolutely, in our view, Your Honor, yes. And so let me just
Many people's view.
So certainly for my clients, Your Honor, and that's why I was saying the argument here really turns Purcell on its head, because Purcell is all about avoiding the confusion and the chaos that can result from last-minute changes to state election law. Now, that may be why, Your Honor, even the state election board is not invoking Purcell. The entity whose authority would supposedly be vindicated by applying Purcell here is not relying on the doctrine. But more directly to what you said, what I was saying, Your Honor, what the Republican interveners say is that Purcell is really concerned more about ensuring that state election law or policy making regarding state election law is made by, quote, policymakers, not judges. That's the way they phrase it. If that is what Purcell is about, Your Honor, it certainly does not bar relief here, because our claims are entirely about defending and vindicating the policy choices about election law made by policymakers in the state legislature. We are asking this court to ensure that the state election board cannot flout, depart from whatever rule or phrase one would want to use, the policy choices made by policymakers in the state legislature. And there is nothing about Purcell that prevents a state court from doing that. In fact, Purcell is a limitation on lower federal courts. It is not a limitation on state courts, and they have not cited any case that applied Purcell to a Georgia state court to bar relief. They have a smattering of cases from other state courts, but to be clear, if a state court is applying its own version of Purcell, it must be doing it as a matter of state law. Purcell is not itself, the U.S. Supreme Court's doctrine, binding on state courts. It's not grounded.
But setting aside the name, there's certainly policy wisdom in saying courts shouldn't interfere by changing election rules and laws on the eve of election. We call it Purcell, call it common sense, call it good judicial practice. So I'm less hung up on the name, and I agree with you that it's certainly not binding on courts here. So I think more productive is engaging policy with policy, but you started with that, which is actually what we're trying to do here is address some last minute changes to electoral procedure that's flowing from an unelected administrative body and could have an impact on the way people are applying the law that was duly considered and passed by our state legislature.
Right. Courts, like other entities, should be sensitive to timing and should be aware of the possible implications of making changes to election law shortly before an election. Now, here, of course, we are asking for a restoration of the status quo that existed until slightly before the election. So again, because Purcell is about avoiding chaos and confusion, we think it weighs in our favor here. And my last point on Purcell, Your Honor, is that I think the implications of their argument are quite extreme and unacceptable. On their view, there is no judicial check available whatsoever, state, federal, anything, for last-minute changes to election law, no matter how extreme, unlawful, unconstitutional, et cetera. That is never what Purcell has been about. And so I ask the court to reject their Purcell argument.
All right. Thank you, sir. Are you good if we keep going a little bit longer? Okay. All right. I'd like now, and I don't mean to leave anyone out from petitioner side, but I think we hit the three designated speakers and pivot to Ms. Young or Mr. Drennan. I'm happy to, whatever order you all want to present, I am ready, and I appreciate your patience.
I think
Ms.
You tried.
Yes.
The
I
lean
get told
in
that all the
didn't
time,
quite work.
that I'm too soft-spoken. I want to start by saying I think that the court has picked up on a number of things that I was planning to make the subject of my argument. And the first is that, with regard to both of these rules, nobody is arguing that these rules were meant to be or can be read to suggest to anybody that their certification duty under the law has been called into question. And it's a fundamental principle in declaratory judgment types of cases like this that we're going to assume public officials are going to fulfill their duties in good faith. And I will say, from the people that I've met that work in elections, that do a very thankless and difficult job, that legal presumption is very valid in this case.
So
And
I happen to live in a county where a member of a board didn't certify, so I'm just wondering when we need to set aside that presumption and say, but when faced with real life examples of a member of a board saying, I know it says shall, but I shall not.
So-
is that, or is the answer to say, but no one hasn't yet, and so that's where we get into this advisory space that I need to stay out of. No one, because the election hasn't happened yet, has said I refuse to certify. And so is that not an emergency action where someone comes to a courthouse open 24/7 on November 13th to say, well, we don't have anything from Forsyth County. And they had to certify at 5 p.m. yesterday, and they haven't. And so here's a mandamus action. Get these people to do the job they're statutorily obligated to do, and let the courts provide that relief then. You don't have to worry about Purcel, but there's not that clear and present danger. There is a forecast of it. I'm trying to balance that with actually have real life examples of very well-meaning public officials saying, because of X, I can't certify, so I won't, even though it says shall. So walk me through that.
Well, correct, that has happened, and the petitioners pointed that out in their brief, but I'm not sure how that helps here, because all that tells you is that if somebody's going to do it, they're going to do that with or without this rule. Or actually, arguably, maybe they won't with this rule. I would like to hope that this rule will put fewer superintendents in that awkward position where they are, feeling like the deadline is coming up and they haven't gotten some information that they felt like they wanted to see, or they're nervous about certifying. And also we don't know what the subjective intent of anyone is. I could imagine a scenario where a single member of the board might kind of do a protest vote knowing that the board is going to certify, but that, again, that's a hypothetical. But let's say you got a majority and they did not fulfill their legal duty. That sounds to me, in that particular hypothetical, like a very strong case for mandamus. And as petitioner's counsel and I can attest, having just done the ballot access cases that rocketed through this court and through the Georgia Supreme Court with, I think they called it dispatch and alacrity. There is time built into the schedule, not a lot. There'd have to be dispatch and alacrity there too. But for a mandamus remedy in that situation where you have and I don't know what the hypothetical would be that would lead to this, you've got that deadline coming up and you've got 3 people that refuse to certify. What the examination rule, working in tandem with the reasonable inquiry rule, deals with that period in between and gives some flexibility, recognizing that what certification looks like in, say, Liberty or Telfair County looks real different than Fulton. And it also realizes that no one election looks like another. There are all kinds of things that can and do happen in election world that might cause a superintendent to have a question. I heard lightning struck this precinct and all the machines went down. How do we know that everything, was correct? I'd like to ask some questions of the precinct leader over there about how they made sure that those numbers were accurate. There's nothing wrong with questions like that. Those are good faith types of questions, and those are the types of questions that should be able to be resolved within the time period. But if there isn't, there is provision in 493 where, you know, as you're coming up to that deadline, you do your best, and you certify, and you turn whatever, you know, the issue is that you think is not quite resolved over to the district attorney.
What about the concern that the petitioners have raised about the takeover provision? So I am now tasked as a superintendent to make a reasonable inquiry. That's not optional. The examination rule says you're permitted to, you shall have access if you ask for it. But the reasonable inquiry is what you shall do. And the state election board decides that wasn't reasonable. In our eyes, that wasn't reasonable. Strike one. And in fact, there were 3 of you who weren't reasonable. Maybe that's strike 1, 2, and 3. So now we're taking over your election operations.
Again, I think that assumes an element of bad faith without any
But maybe
evidence
very
for
good
that.
faith. Maybe they didn't make a reasonable inquiry. Maybe they were drinking coffee and said, "Where do I sign?" and sign here. And there's no evidence that there was a reasonable inquiry made. I'm not putting bad faith on anyone's side. I'm talking about the uncertainty, because that's what the petitioners have flagged. I don't know what it means to make a reasonable inquiry. Does that mean in that 5-day window, 10 hours a day of inquiring is enough? Is 6 hours a day? Every county's different. But I can tell you there are plenty of counties where you could work nonstop during those 5 days, and if your vision of reasonable inquiry was, and clearly in some people's minds it now means hand counting ballots. Can we do that in that amount of time? I don't know. Is that what's required? So it's the uncertainty, and I'm throwing hypotheticals at you because of the uncertainty. So what is the comfortable answer you can give me that as a superintendent, I don't run the risk of having the state board conduct an investigation and level a strike against me or my board because I didn't meet their expectation of reasonable inquiry when there's no description of what that means?
Well, again, I would say, you know, as with any enforcement case that you have under election rules, first of all, you assume that everybody involved, the investigators and the board, are going to act in good faith. The respondent always has due process, rights to be heard.
I don't know how the strikes work. You say there's due process. The takeover provision, you're going to need to educate me. I don't know what the due process is. Does the superintendent have an opportunity to defend against the allegation, or I don't?
There's an opportunity, of course, to defend against that. And I'm trying to imagine what the hypothetical facts would be that would lead to that suggestion being made. But if there is some credible allegation of dereliction of duty, then I think that it's appropriate to bring a charge for violating a rule. But of course, you would explain why your inquiry was in fact reasonable. No, we didn't get to hand count every ballot at this precinct because that's impossible given the time constraints or the limitations on personnel. And I think the argument in terms of why your inquiry was in fact reasonable would be reasonably considered by the board, and then there are remedies beyond that under the APA that could be pursued if that was something that the respondent was concerned about accumulating strikes and thought it was worth their time to pursue that.
Sure.
But just as somebody that's done enforcement cases, there are what I tend to see is that there's a burden of proof of preponderance of the evidence, and that matters. You're not going to have a frivolous accusation of, oh, you didn't do a reasonable inquiry because I saw you drinking coffee and you're in Telfair and it only took you 10 minutes. I'm going to charge you with not making a reasonable inquiry. A reasonable inquiry can be, I'm
a superintendent in a small county. I have, we have one precinct, and I trust that precinct manager, and that manager told me what the numbers were, and everything, there was no lightning strike, no pipes burst, no, chlorine gas plants exploded, everything was fine, and, I can sign off on this in 5 minutes, and that can be a reasonable inquiry in that situation. And, in other precincts, there may be a bit more. But this rule allows that flexibility, and as Your Honor pointed out, doesn't mandate anything specific. I read a really great article, line in an article that suggested that this rule was going to basically make, election superintendents live action role play as members of the Bloodhound Gang, that they were being directed to go and just, with their magnifying glasses looking for non-existent evidence of fraud, and that's not what this is doing. This is saying, make a conscious and clear decision, that the canvassing, computation, tabulation, all have the appearance of being accurate and correct, and then certify within the deadline. Everything else that we're hearing here assumes malevolent intent. And to the extent that that happens, and I certainly hope that it won't, the remedy for that is not to strike this rule, because a malevolent actor is going to act malevolently with or without this rule. And hopefully this rule will help give guidance to people who are good faith actors, but who may have felt like they weren't given the opportunity to certify in a way that they felt comfortable with before.
So a fair amount of the relief, that there is an argument made by petitioners that the rule should be invalidated, but most of the relief, sort of the main thrust of the relief, is more clarification that the rules are there, they don't take precedence over statute, and certification is mandatory, and that deadline is mandatory, and so these rules might supplement or augment a superintendent's ability to do her job. But that's what I read the declaration would say, if there's going to be a declaration. And that to me doesn't assume malintent. It is a cry for clarification, in particular from the superintendent petitioners, as opposed to the voters or the party. And I'm wondering if the board has a perspective on the value of clarifying the interplay between the rules and the statute. Or maybe you started with that, which is what needs clarification? There's law and there are rules, and rules can't change the law.
Yeah, I think that's how we started our brief, was that basically you're being asked to sort of reaffirm that the law says what it says and the regulation says what it says, and to the extent that you're being asked to do anything beyond that, you'd be in advisory opinion territory, because, to the extent that, there's any question about this rule, it really should be able to be resolved by looking at the clarity that is in the statute and that is in the examination rule, that yes, you have to certify, that all of these things are talking about tasks that, are consistent with the statutory framework of what happens between the time the polls close and the time of certification. You go through the canvassing, the computation, the tabulation, and you're looking to make sure that it has certain indicia of reliability. This just gives that kind of added assurance to election superintendents that, they can feel good about what they're doing. That, if they have a question, and, a good faith question, not a pretextual question that is being used as subterfuge to avoid their legal duty, but a good faith question that they'd like to have answered, if possible, before certification. You've got this window of time to do it, and it should be done if possible. If it's impracticable, 493 has a provision to address that, where you finally just put a hard stop on it, and you do your best. Basically, it sounds to me like an opinion from the court would be, yes, the statute means what it says, and yes, the rule says what it says. And really might be nice in a lot of ways, but it's not really a proper use of the statutory remedy. I do want to talk just really briefly about standing. We've stipulated that the superintendents that are subject to the rule fit the criteria for statutory standing under the APA. So I don't know that how much more is needed to discuss other plaintiffs. But with regard to the voters and the organizational plaintiffs, obviously voters need to go vote, period. Everybody should go to the polls. And the voters are not subject to these rules. In fact, their job is done by the time the polls close. And that's when this rule begins. And I would say the same is true for the organizational plaintiffs. The organizational plaintiffs aren't subject to the rule, nor do they have, an ability to come in and direct these superintendents in doing their job. To the extent that, they have any thing to do about the rules, it's, again, to tell the voters, go vote. And, that is something that I would think that they would be doing with or without this rule. I'll talk really briefly about the sovereign immunity arguments. Basically our understanding of State versus Sass and Level at this point is in a case like this, you got to pick a lane. And
remind me, I know that the primary provision under which petitioners are traveling is the declaratory judgment action pursuant to the APA, but you allude that elsewhere they reference Title IX, and so your argument is because you strayed over there, then you need to be suing the state and not the state election board.
Correct.
And we all know the consequences of getting that wrong.
Obviously under 501310, there is a statutory waiver. Under the declaratory judgment statutes, there's a statutory waiver. The thing that caught the attention of our office in reading the petition was paragraph 50 and 131 to 138, where it seems to suggest that there's a declaratory judgment claim in addition. We'll leave it to the court to determine whether that's in fact the case, and if the court does agree that that is an issue, we would be happy to work with plaintiffs, as I understand has happened in the Adams case, to be diligent.
Resurrect this in a different format. Got it.
Correct.
Okay.
And you know what? I think that's all I've got for now, unless you have any questions.
No, you helped me work through the questions that I had. I appreciate your work.
Thank you.
All right. Mr. Drennan.
Good morning, Your Honor.
Good morning.
Got a PowerPoint. I'm not going to go through all of it, but I'm going to hand it out if that's okay.
That is very okay.
And then I'm going to do my dead level best to put it on the screen.
All right. You're not going to try to conscript Mr. Carver to do that?
Since we're on the record, I'm not going to comment.
Exactly. I noticed you keeping him away from the computer.
Yeah, may I approach, Your Honor?
Please.
Thank you. And as luck would have it, the arguments today have not been presented in the order that I anticipated.
Never are.
So we're going to jump around briefly. I'm going to share my screen. Yes, ma'am. As soon as I can accurately share the correct screen, I will do that. All right. Your Honor, I'm happy to start wherever the court wants me to, but
Well, give me an overview, please, of what the parties are going to be addressing. Ms. Young tackled some of the perspective from the respondent side, and so I'm assuming you'll cover something different. And I didn't remember, had you foreshadowed when we first started what that was?
Well, Your Honor, I think 3, maybe 4 points. One, there's not a bona fide dispute here Two, the rules are consistent with the law. And frankly, if someone has a concern about what their obligation is under the rules, they should look to the law because those same obligations exist under the law. Third, the rules are actually necessary to ensure votes are counted. There are examples where that hasn't occurred. And then fourth, I'll briefly address the Purcel arguments.
Okay. What I'd like to start with then is not that the rules are necessary. I follow that argument, but whether they are sufficiently clear that they don't require any declaration, because that's really what we're here for, is this question about, well, okay, the rules are here, and setting aside the challenge to validity because there hasn't been a concise statement yet, or whether the examination rule isn't sufficiently uniform because it doesn't say superintendents, it says boards. I don't think we need to go there. The rules say what they say. They certainly can't countermand or overrule or modify the statute, so they supplement it. But if they supplement it in a way that creates uncertainty that is potentially harmful, that's the main argument I'm hearing, that superintendents are saying, we don't know how to proceed, or the way we're proceeding is going to cost a lot of money, there's uncertainty, there's expense, there's harm, etc. That's where I think you'd need to push back if you think no relief should be granted, although the relief that I think is primarily contemplated here isn't saying the rules are out, it's simply saying the rules operate within this universe, which I think Ms. Young's point was, yeah, they operate in the universe of the law, which no one is disputing.
And frankly, Your Honor, I don't want to borrow a phrase, over-egg the pudding. I agree. The first point of construction of these rules needs to be that they're to be read consistent with the law as it exists. And 21-270 of the Georgia Code requires an inspection systematically and thoroughly of the conduct of elections. And this is by a superintendent, or as the courts noted, superintendent and boards can be used effectively the same. So the law requires an inspection of the conduct of the primaries and elections, and it requires superintendents to receive from the poll officers the returns, to canvass and compute those, and to certify the results. So, and I'll supplement with the second code section, 21-493 requires a superintendent to examine all of the registration and primary or election documents, and it says here whatever because that's what the code section says, but superintendents are required before the rules ever come into existence to examine, and it says shall, so this is a mandatory provision of the law. They must examine all the documents related to an election. I'll hopefully fix it whatsoever. Whatever those documents are, they're required to do it. And then to supplement the point, if error or fraud is discovered, they're required still to compute and certify the votes, but they're required to do it in the word of the legislature justly, regardless of any fraud or erroneous returns presented, and then to report those facts to the appropriate district attorney. So if we read...
Can you go back to that slide, please? The phrase, all of the registration, and here it would be election documents, not primary documents, is that phrase defined elsewhere such that really the statute limits superintendents to looking at certain things? And so then the rule is changing the statute because it's saying you can look at other things, and maybe a reasonable inquiry means you better look at other things, which is not all of the registration and election documents. All is a big word, only 3 letters, but pretty expansive. But if that phrase, registration and primary or election documents, is defined elsewhere and it's limited, then we now do have some tension between the rules and the statutorily defined role of the superintendent.
And Your Honor, I'm sure somebody will correct me if I'm wrong. It's hard for me to prove a negative standard here, but I'm not aware of it being defined somewhere else.
Okay. No, I didn't mean like in Title 5, but it'd probably be in 493. 493 is very long, and it says a lot of stuff. I just wasn't sure if in Chapter 2 of Title 21 there was some definition of that phrase. And I don't know otherwise, so I'm not trying to trip you up.
Okay. I read it. I don't recall that.
Okay. Me neither.
But I agree with you that one, this is mandatory, and two, it's very expansive. To use the phrase all and whatever would suggest all the documents that there are related to it for that particular jurisdiction, whatever those documents are. But collectively, the requirements under Georgia Code, a superintendent is required to inspect systematically and thoroughly how an election was conducted, to examine all the documents associated with the election, to canvass and compute the returns, to compute and certify the votes justly, and then to refer fraud or other discrepancies to the appropriate district attorney. And as we said here today, I have not heard petitioners cite one aspect of either rule that is inconsistent or different than what's required here under the law. And I think that's a requirement they must make to have this court invalidate the rules, or, frankly, to otherwise provide guidance. We talked about that briefly. The City of Atlanta versus Independent School System requires it for this court to issue a decision. It must relate to an immediate legal consequence. We don't have that here. Mere disagreement over an abstract meaning or the potential validity aren't sufficient. Again, I tried to count, but I lost count. Whether it's in the affidavits or in the argument today, there's a possibility this may occur. Someone may say this. Someone may do this. They might not certify. All these things are mere possibilities or potential things that could occur, but none of them are actual immediate legal consequences under the rule, and I don't think this court can issue an opinion based on that. Your Honor, with regard to Purcel, one, that this court couldn't apply Purcel or some similar rule. I think they've missed that here. The court, in its equitable power, certainly could apply its own judgment similar to Purcel. Purcel, the purpose of Purcel is really a separation of powers issue. We have an executive branch that writes rules or expounds upon rules, and Purcell respects that by saying we've got experts in policy to make election rules. The court's not going to substitute its opinion for those rules. I didn't think right.
No, I just wanted to, everything good back there? Okay.
And to not substitute its opinions for what those rules should be, but instead, particularly when you're this close to election, but to instead follow what those policymakers and experts have put in place.
Right, but help me address the tension created by the fact that it's good policy, and I don't think really there needs to be a big debate about whether Purcell, the case, is importable to Georgia. Good policy ought to be importable into all 50 states. But we're dealing with a situation where new rules seem to pop up every 20 minutes, and the election is getting closer, not further away. That would seem to create a natural tension where it can't be that there reaches a point where courts aren't allowed to be called into service by concerned litigants, and yet an agency can keep generating rules. Because then that would mean that there's a window where unreviewable rules can be issued. They could be procedurally defective, they could be substantively defective, they could be unconstitutional, and they're incapable of review because this agency, this rulemaking body, says, oh, we're within the Purcell window. Now's the perfect time to say, let's count ballots by hand. And we know a court can't look at that new rule because it's too close to the election.
And I can appreciate the court's concern there. I don't think that's what we have here. Here we have a rule that was first submitted back in April. Rules that were first submitted back in April. The state election board completed its process for addressing those rules in August. And again, I don't know how much this is really Purcell, but if you take the principles of Purcell, look at the rules that were promulgated, and look at the actual law, we're not changing the law. Reinforcing or re-emphasizing, I think might be the best ways to describe it, the law that was in place beforehand. So if someone has a concern that something's changed, they need to go back and look at what the law required. They should not have a concern that they're doing something new. They're being, again, reinforced, re-emphasized to follow the law as it existed. Because of that, I don't think there's a concern that there's some new requirement that's taking place, and I think Purcell would at least the principles of Purcell would be applicable and controlling on that. And I recognize at the time, I'm happy to take any other questions.
Let me see. Nope, I don't think so. Appreciate it.
Thank you, Your Honor.
Thank you. Let's pivot back to petitioners. Happy to hear your responses in general, but I want to start with an exchange I have with Mr. Drennan. And I've been trying to find, 493 has so many sections and so many words, but he seized upon a section where the language was superintendent should look at all records. I'm paraphrasing, and I can't find it. Not because it's not in there, but just because there are many very long paragraphs. But if 493, so we're clear, OCGA 21-493, already says superintendent should look at everything, how is either rule that we're here to discuss doing anything other than here's another way to put 493? Let's discuss.
So I don't have the full text of 493B, 493 in front of me, but I believe the reference there is to 493B. And
Okay.
so I would commend you to read 493B because I believe that 493B refers to an if-then circumstance. If a particular discrepancy arises, it is then appropriate for the superintendent to evaluate those documents. And so I actually think that's a fairly good illustration of our argument, rather than the statutory scheme in which the decision to look at all of those documents arises from a particular circumstance described by statute. The examination rule modifies that to say that it's actually just generally available at the whim of any member of any superintendent.
Got it. And you're right. Now that I have all of B here, and B requires the superintendent, before computing votes cast, to compare registration figures with certificates. And it's if upon consideration of those things, it appears that an example would be there are 800 registered voters, but there are 801 votes. Uh-oh. Then you take this deep dive and look at everything. So that makes sense. Superintendents are empowered to take a deep dive if that initial check, which is what the statute requires in general, doesn't add up. And so your response, Mr. Thorpe, is that the two rules make that now the norm. You can take a deep dive anywhere, anytime. I don't know that's necessarily a bad thing, but it has the ripple effects that you've described that generate for some of your clients the uncertainty that you've also described. But that helps clear up.
In our view, it yields some degree of purported discretion on the part of individual members of superintendents. And that connects to what I think is a broader theme as you read our petition, which is a lot of these choices have been made by the General Assembly about if-when circumstances in which superintendents will look at specified information. This is a comprehensive, and I think we call it a reticulated scheme. And there's a network of steps that happen along the way in order for tabulation and canvassing to occur. Our concern with both of these rules, frankly, is that they interpose this additional layer of inquiry that is totally undefined. And I think some of the colloquy with the SEB on this question illustrates that it's totally undefined, and allows individual members not to follow those statutory requirements, but to determine spaces where they think additional inquiry is necessary, but the Georgia General Assembly did not. And so that gets back to the question you asked at the outset, which is, does anyone think that these SEB rules can expand upon the authority or change the statute? I think everyone's answer was no.
The corollary or the companion to that question was, is there anything in the statute that says you can't do these things? In other words, do the rules conflict with? And I don't view it as a conflict if 493B says, if in a certain scenario your spider senses start tingling, you can go through all the records. And here's what qualifies. And now there's a rule that says, to be thorough, if you want to look through all the records because you're being tasked to certify the election results for your county, you can do that. That is expansive. It changes the role of a superintendent. That may have unintended consequences. It may create uncertainty. But I have not identified any provision in Chapter 2 of Title 21 with which that is inconsistent.
So it is not certainly in conflict. Otherwise, we would only be making the argument that the rules are necessarily invalid, not that they can be construed consistent with the law. But I would give you an example, and this, I don't have a pin site to this, that we can certainly provide it. In the discussion of the initial Heakin petition, the reasonable inquiry rule, there was a discussion that SEB member King participates in, where she is asking about whether the question of whether a vote is legally cast is part of what can be evaluated in the discussion of reasonable inquiry. That is an example of something that, from our perspective, goes so wildly beyond the steps prescribed by statute. And I'm not saying that to attribute any sort of bad faith to the question. It's just not a question that is anticipated by the steps that the superintendent is involved in at that time in the canvassing, tabulation, and certification.
Right, or how, not what a superintendent's qualified to opine on either. Okay.
I'm in complete agreement. So I think that's an illustration of why something that is not directly in conflict can nonetheless sort of supplement in a way that at least seeks to expand or arguably expands the SEB's authority. So I also think that speaks to some of SEB Council's examples of, how do we have flexibility to resolve questions? Our argument is that the reasonable inquiry rule provides all kinds of flexibility but no direction, right? There is no definition in the rule that helps superintendents understand when reasonable inquiry has been satisfied. And so it is then left to the determinations of individual actors. And I think we have plenty of practical evidence, as Your Honor outlined, that in some circumstances that may support a decision to delay or otherwise vote against individually or as a board certification. I do want to address Ms. Young's argument about whether this is better as an emergency action that would get filed at 6 p.m. on November 12th. And in our view...
So I want to be clear, I didn't hear Ms. Young say it's better.
I'm sorry.
My exchange with Ms. Young was, isn't that the way to handle this? That the respondent's perspective is, these are potential concerns. Your perspective is, no, they're real right now. Read the affidavits. Today they're real. Pushback is no, because none of this has happened, and we don't have a non-certification, we don't have a foresight where 3 refuse to certify and 2 are ready to certify. Should that come up, there's a tool out there, and that's mandamus. And you go to a judge in Forsyth, not in Fulton, and get that addressed. That's what I heard her say. Not better, but if you are pulling tools out of the toolkit, it's a Phillips head for a Phillips screw, and you are trying to use a flathead in a Phillips screw.
That is a much better characterization of her argument. Our argument is that it is definitively worse. And the reason why is that this does present an actual and justiciable controversy. And the circumstance in which we or whoever has to bring a mandamus action on the evening of the 12th. What we need in that circumstance is a clear judicial pronouncement that the law requires X. And that is part of what we are seeking in this case, is clarity that will govern all actors in that circumstance. We think we've brought a case that allows this court and whatever reviewing courts to illustrate that by way of a binding opinion that we may need to use on November 12th or whenever such an action needs to be brought. But to wait, to not decide that case when we think it's decidable, is a definitively worse outcome for all parties involved.
Okay.
There are 3 other very sort of grab bag arguments that I wanted to address, if Your Honor would indulge them. They're very
Give me
short.
1 second. Is Deputy Gordon around? Yes, please. Thanks. All right. Yes, 3 brief arguments.
And it's actually just 2.
Even better.
So the first is with respect to standing cases like Atlanta versus APS. I think if you review those cases, what you will find is those future contingencies were not examples like we have here, where a certification vote is definitively going to happen. The question in Atlanta versus APS was where Atlanta had annexed a bank building that had no people in it, could APS use that to challenge a provision that would be applicable if Atlanta had annexed somewhere with people that would have tax revenue that could go to the schools? Fundamentally different circumstance, not a future contingency. What we have here, for the reasons we've discussed, we don't think is a future contingency.
Okay.
Lastly is the sovereign immunity point. To be clear, we are not making a declaratory judgment claim that goes beyond 50-1310. We are not making a claim that is pursuant in any way to paragraph 5. This court should find that to the extent it has to interpret what sort of declaratory judgment claim we are bringing. The reason that 942 and 943 are cited in the jurisdictional part of our petition is that 50-1310C expressly incorporates the provisions of Chapter 4 of Title IX, and 942 says it's the superior courts that have jurisdiction.
I took it more as procedural. I mean,
Correct.
the jurisdictional hook that keeps you away from SAS Group and all that cluster is Title 50. But it then references, it doesn't have its own declaratory judgment law in terms of procedure. It says, see Title IX for how you move forward with the declaratory judgment that you're pursuing under the APA.
Correct.
Okay.
And that is the reason we've cited those provisions, and more than that, 50-1310 requires that we name the agency as a party. So
Right.
that was part
Okay.
of it.
All right, got it. Are they done? All right. Ms. Young and Mr. Drennan, you had less time because you covered what you needed to very efficiently, but I want to make sure if there's anything else you want to add, you both have an opportunity to do that, and then we're going to wrap on Avi Rahman, take a break, I have a verdict, and then when we come back, we'll pivot to Adams versus Fulton County. Anything, Ms. Young, and you don't have to add anything, but I don't want respondents to say, wait a minute, these petitioners talk forever, and we didn't talk a lot. That's okay. There's a celebration around that, but I want to make sure if there's anything you want to add, you get a chance to do that.
Just two real quick points. I don't think it'll take very long, but a comment was made about during discussions on the rule, a statement made by one of the members about looking at whether or not the votes were legally cast. I wanted to say two things about that. First of all, there are many cases, one of them is Olevic versus State, that says when we're looking at the intent of a statute or a rule, we don't look at comments like that and that's for good reason. Having sat through a lot of these board meetings, there are a lot of questions and ideas that get knocked around, and it is not imputable to the rule or to the board's decisions itself when members ask questions that may, in hindsight, seem a little strange or unusual. It's sort of the nature of the process.
Sure.
The second thing, we didn't really get I forgot to get into because I was, off track on my notes, but I wanted to briefly mention the procedural issue that the petitioners raised with the notice and comment, and just say a couple of things
This is
about
the
that.
concise statement that is supposedly on its way? Or you're referring to something different?
Yes, the
Okay.
concise statement. First of all, for the reasonable inquiry rule, it's not required because it's an amendment. Second of all, for the examination rule, I'll say that one is forthcoming. I don't think the law puts a specific deadline on that. And the other thing I'll say is, and I feel obligated for their staff who is inundated, to say that, not seeing out of a multi-page document a line in there and recognizing it as an action item can't possibly be the standard that would invalidate a rule. And now that they're aware of it, it will get taken care of. But I just
Well, that
wanted
seems-
to make a little plea for some that it's substantial compliance there. And the other thing is, there is no shortage of public comment on this rule that the board has heard and the public has heard. So,
No, I hear you. I don't know that substantial compliance fits this one because it seems to be part of, I can't remember A and C, but there were certain aspects where it was exact compliance or express compliance, a phrase I hadn't seen before, and I think that concise statement falls into that window. But that statute also says it's due after the rule is promulgated. And so you haven't missed that deadline because we're in that infinite period of after the rule is promulgated. Sooner will be better.
yes, thank you.
Thank you. Mr. Drennan?
Your Honor, two very brief points. One, we were talking about 21-2-493 with regard to the broad scope of reviewing documents.
Yes, sir.
And I would just also point the court to 21-270 that again makes it mandatory for an election superintendent to systematically and thoroughly evaluate the conduct of primaries and elections and precincts, and the court can read the rest of it. And then the last point, Your Honor, to the extent they're asking the petitioner...
Which, just so that I have the, because I am taking notes here, 21-270 has 1 through...
8 and 9.
8 and 9. Okay,
Thank you for asking.
great.
And then the last point, Your Honor, to the extent you're being asked to issue an opinion that would provide further guidance on these rules, effectively what the petitioners are asking you for is for the court to say what is reasonable across all counties in the state before any factual occurrences have been made. Your Honor, I'm not sure that there could be anything more speculative than asking for that. And again, I think that further shows why this court should not issue a ruling in this case, or one in favor of the rules is what should be issued. Thank you.
Okay. Thank you. I appreciate the input from all of you. There was a lot of writing done on a short schedule. That's been valuable, and I appreciate your comments today. I'm going to ask those of you who are at the tables now to step back. You have to take the verdict in the criminal case. Promise the folks in Adams versus Fulton County we will have a full hearing of your issues as well, but we got to do this verdict first. So you're free to stay in the courtroom. You don't have to, but I just need the tables.
Would you mind, just that very quick housekeeping question as to exhibits? Would you like copies of the exhibits that we moved forward?
So great question. I believe we have digital copies of everyone's exhibits. They were emailed, and so I've got them. But to be made part of the record, during the break, you should speak with our court reporter to figure out the best way for her to get those exhibits. Okay? Thank you so much.
Please.
Am I okay to just turn off from his computer?
I do. I'm going to go back. We're going to take a few minute break, and once that clears, we have one defense attorney. We have Mr. Rose back. Steve. Wait, Steve. All right. And we have
I'm actually Daniel Falchuk.
what?
Yeah, let me get yeah.
Okay, let me get my notepad.
I didn't know you did great. Your partner wasn't so good, but you were awesome.
I think you don't need business cards.
Well, I do. I just need to know what you're. Are you going to count the second one?
We'll leave your second one. That's easier. That is me.
Okay, great. And then, I
We will cover that. We just need one for all petitions, so we'll cover that with this. Yes. Thank you very much.
Thank you. That's amazing. Like, where's Alex? And his card. I got horrible handwriting.
I appreciate it. I'll send the on behalf of the plaintiff.
I know to give you our PowerPoint.
I assume it's not the one in front.
Will you? Yeah, will you write down your email? This is the third one? You should not do two at once.
And if you'll just see,
Yeah.
same thing with office. That way, in case you misspell my name and put Melissa instead of Marcy, because a lot of people do that.
And mine will be coming from Reed at the end.
Okay, okay. Yeah, it's just, it's the same thing, it's just office.
Okay. Beautiful.
You'll be here for the next one, right?
Yes, I'm not going anywhere, we're just not gonna be sitting here.
Do you need
No, not be here. Thank you for your patience.